Hello, scroll friends of the world. We are back with another Karen Read document. This was filed on August 1st, and this time we are hearing from the Commonwealth. So, things had been a little bit quiet, and as many of you may know, we do have the hearing coming up this Friday. That's August the 9th, and that's the hearing in order to hear argument on the defense's motion to dismiss. So I will be covering that as well. But as things were a little bit quiet, I thought to myself, I wonder if jurors are calling the Commonwealth, because they had called the defense. The defense had immediately come out with, documentation, the affidavits of these different jurors, and I would imagine the jurors, now that they're allowed to, are probably keeping up with everything going on, and potentially maybe they are seeing that nothing is happening. So it made sense to me that they would be then calling the Commonwealth. However, we weren't hearing from the Commonwealth. And I thought, that's interesting, right? Well, turns out they had been contacting the Commonwealth, and this was happening starting July 21st, and the Commonwealth did not file this until August the 1st. So let me zoom in a little bit so you guys can see better, and we're going to go through this. All right, so Commonwealth of Massachusetts versus Karen Read. Here we go. So, Commonwealth's post-trial notice of disclosure. Now comes the Commonwealth in the above captioned matter and provides notice regarding the defendant's post-trial claims regarding the jury's deliberations. On Sunday, July 21st, 2024, Assistant District Attorney Adam Lawley received an unsolicited voicemail on his office's phone line from an individual who identified theirself as a juror by full name and seat number. This individual stated, quote, "It is true what has come out recently about the jury being unanimous on charges 1 and 3, end quote. On Friday, July 26, 2024, Assistant District Attorney Adam Lawley received another unsolicited voicemail on his office's phone line from the same individual who stated, quote, "Can confirm unanimous charges on 1 and 3 and as not guilty, and as of last vote, 9-3 guilty on the manslaughter charges, on the lower level manslaughter charges," end quote. The Commonwealth did not respond to this individual, as the Commonwealth is ethically prohibited from engaging in discussions about the jury's deliberative process. Okay, well, first of all, they can engage with them without getting into the deliberation at all, and we've discussed that at length, so I'm not even going to elaborate more on that. But I think at this point, you've probably heard it from me or maybe other people covering this trial that it is entirely possible. And a great example, Alex Murdaugh, right? The evidentiary hearing with Chief Justice Toll, just a great example, just in recent times, where you can question the jurors and you don't have to get into the deliberative process. So that's really an excuse, if you will, to not speak with them, in my opinion, because it's totally doable. And we will also take a look, after I finish reading this document, we will take a look at, again, at the lower level manslaughter charges and talk about what this might mean. Okay. Similarly, the Commonwealth received emails from 3 individuals who identified themselves as jurors. These individuals indicated that they wished to speak anonymously. On July 16, 2024, the Commonwealth responded to the emails by stating that the Commonwealth would, quote, "welcome the opportunity to discuss the evidence or the Commonwealth's case. However, we are ethically prohibited from inquiring as to the substance of your jury deliberations. That would include your individual or the jury's collective thought process, the content of your deliberations, or the reasons for your decisions," end quote. Well, okay, I have to go here because, dude, this is really weaselly. Weasel alert, goat and weasel alert. Okay, so no one is saying that they need to discuss the evidence or the Commonwealth's case. This is crazy. So the jurors wanted to speak anonymously. They wanted to speak to them, and they said no, essentially. They said because, so the jurors wanted to speak to them, and then the Commonwealth responds with this, quote, which is assuming what the jurors want, which is a problem in and of itself, saying they would welcome the opportunity to discuss the evidence or the Commonwealth's case. Well, the jurors aren't asking for that. However, we are ethically prohibited, right? Okay, so this is all true, right? The substance of the jury deliberations is accurate. They can't discuss that, right? All of this is true. The problem is, like, what they're saying, these things they can't discuss. And that's true. However, that's not what needs to be discussed. Like, all they need to do is inquire about the verdict. Dude. I don't even, this is next level right here. If I were one of these jurors, I would come back and say, we are not asking to discuss any of this. We don't need to go through the jury deliberations. We don't want to discuss the evidence. We just want to talk about the verdict. That's what I would, but they don't, I mean, that would be asking a lot of a juror, right? It was further explained that the Commonwealth could not promise confidentiality, dude, and that the substance of any communications may necessitate disclosure to the defendant or the court. All three jurors declined to further communicate with the Commonwealth and provided no information about the jury's purported votes. Well, of course they didn't after that, right? Oh my God. So first of all, that's misleading because, let me go back to this page. As we know, it's entirely possible to keep their identity confidential. We've seen this already from the defense's court filings where they just use juror letters, A, B, C, whatever. Even the Commonwealth previously had that whole affidavit from a juror, and they called the juror Juror Doe, and that was quite lengthy. So they've already shown that they can do that with another juror. Like, not only has the defense done it, but the Commonwealth has done it. So they've just basically intimidated them and scared them into not saying anything else. That's justice right there. I'm being sarcastic. So, all right, not guilty, and as of last vote, 9-3 guilty on the manslaughter charges, on the lower level manslaughter charges. So let's take a look one last time just to refresh everyone's memory of what exactly that said. Okay, so here's the verdict slip. So just to refresh everyone's memory, so this is the second offense, manslaughter, and then the lesser included. So that juror said 9-3 guilty. So this is the guilty of lesser included charge of motor vehicle homicide, which is the felony OUI, liquor, and negligence. And we broke down the elements of each of these, every single charge, including the lesser included. We broke down the elements of all of that in one of the live streams. I will link that in this video's description, and that part should be time-stamped. But we went through as per the jury instructions, and I actually typed up, as Judge Bev was reading it, all of the specific to Massachusetts, right? What are the elements for each of these different charges, including the lesser includeds? And then I typed that up and put that on the screen, so that, and it's scrolling at the bottom, so you can actually see what all of those elements are. But basically, this is the lesser of the lesser includeds on this second count. Okay, so now we're going to pop over to the defense filing. Okay, so this was just filed yesterday, so August 5th, from the defense. So here we have supplemental affidavit of David Yannetti in support of defendant's motion to dismiss. I, David R. Yannetti, do hereby depose and state that the following is true to the best of my knowledge and belief. And then I'm not going to read these because we've read these before a million times. Okay, so here's what we need to see here. On July 31st, 2024, I received an unsolicited phone call from someone who informed me that he or she was a juror at the trial of this matter. The caller informed me of his or her full name, which was confirmed, and this was Juror B. During my phone conversation with Juror B, he or she confirmed for me that the jury reached unanimous not guilty verdicts on indictments 1 and 3, and then, of course, they're deadlocked on the second indictment. Juror B told me that he or she was familiar with the affidavit that I had previously filed in support of this motion. Juror B confirmed for me that the screenshot of a text message exchange that I referenced in paragraph 4 of that affidavit was accurate. Specifically, Juror B confirmed that he or she had texted it was not guilty on second degree and split in half for the second charge. So that's different from what we heard from this juror who called Lolly and said 9-3. But, you know, that's people's memories, right? It's also why it would have been nice if they had been questioned at the time when this mistrial was declared. But anyway, when the judge sent us back with that Hernandez thing to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. They gave us free counseling forms when we left. Juror B clarified, however, now this is the thing that we kind of read this and thought, okay, this is probably what they meant, right? But now Juror B is coming out and confirming, right? They meant to write, quote, no one thought she hit him on purpose or even knew that she had hit him, end quote. So that's interesting. So I think that what I had maybe anticipated that to mean, or like what they had meant to say, was that no one thought she hit him on purpose or even hit him at all. But what Juror B is saying, to clarify, I'm glad they did, is that no one thought she hit him on purpose or even knew that she hit him. What's interesting is they're not saying anything about even didn't hit him at all. And But they're not saying they didn't think that, right? Like, it would be possible for this to be true, where they could say no one thought she hit him on purpose or knew that she hit him or hit him at all, right? That could still, like that, this isn't ruling that out, but it's also not confirming that, which is interesting. So let me read the rest of this. Juror B believes that every member of the jury, if asked, will confirm that the jury reached not guilty verdicts on indictments 1 and 3. Juror B believes that even jurors who were leaning toward a conviction on some part of indictment 2 will confirm that the other 2 indictments were acquittals. He or she believes that the other jurors have been reluctant to come forward because there was so much public and media attention focused on this case. Okay, so just walking down this road of what this would mean, whether the split was in half or whether it was 9-3 on this second charge, right? Even if it's the lesser of the second charge, like we just looked at, right? The felony OUI, I think is what they call it. If we go with this sentence right here where the little hand is, and we say, okay, well, no one thought she hit him on purpose or even knew that she hit him. If we go with by the omission, right, by omitting that or hit him at all, because of the fact that that isn't there, if we walk down the road of, does this mean that there were some that did think she did hit him? So that would mean, according to this juror, that in the instance that some jurors thought she did hit him, what they're saying is that she didn't know she hit him and she didn't hit him on purpose. So I wonder if maybe part of what the split was did she hit him, right? And that maybe some thought she didn't, and maybe some thought she did hit him, but that she didn't know she hit him or hit him on purpose. Potentially. Ostensibly, that would have to be the case, because if all the jurors agreed that she didn't hit him at all, then right, they would have to logically come to a not guilty on the second indictment as well, right? She has to have hit him. So what's interesting about that is this. I know that I'm not alone in saying that, looking at the expert testimony about the actual injuries with the car, looking at Trooper Paul, and then you had the ARCA dudes, it seemed pretty clear to me, and again, I don't think I'm alone in saying this, that he was not hit by a car. I mean, my personal opinion is that he was definitely not hit by a car. Thinking through it logically, if I try to imagine what some of the discussion might have been with the jurors, right, it might have been, well, then how did all the taillight pieces get there? Like, I've been kind of in the position that, we don't really know what happened to him, right? Unfortunately. But I don't think he was hit by a car. My thought in terms of like the cover-up, quote-unquote cover-up or whatever, right, or being framed, was sort of along the lines of, like, and anyone who's been following my coverage of this has heard me say this before, that potentially what happened to him was an accident, potentially, right? And that maybe he fell and hit his head on something, whatever the case may be. I've always been kind of leaning a little bit towards the fire hydrant, but whatever. Let's just say that no human was involved in any type of this accident, right? But that because everybody that was there was all so drunk, right? And then no one knew what happened to him, that could be why people who were at the house, right, the McAlberts and whatnot, kind of decided to try to throw Karen Reed under the bus because they didn't know. And I've always used that example of the fancy clue dinner party, right? They're all looking around at each other like, wait, nobody knows what happened. Nobody remembers anything. That means I could have done it, or the person next to me could have done it, right? And, like, they don't really know. But they all kind of band together and throw Karen Reed under the bus because she wasn't at the house with them. Like, in other words, in my mind, it couldn't be ruled out that this was just some sort of accident that didn't involve anybody else. But that because nobody knew what happened and didn't want to get in trouble, right? And so they didn't want to be charged with murder. In other words, it's almost like because they went so far, they kind of made it worse in a way, right? Like, potentially. To me, it seemed almost kind of like more plausible that he had that accident on his own, and then the McAlberts, and being all, nobody knew what happened, no one could remember anything, they were all drunk, that they were kind of like, well, we don't really know, so let's all, just in case, let's just, band together and then throw Karen under the bus so that way we don't get in trouble, right? Versus them actually having some involvement and then covering it up. So my thought was, it was more like just to try to make sure that they didn't get in trouble versus like a planned thing, or, if that makes sense, right? And either way, whether it was a planned, we want to kill him, or it was an accident in the basement, or whatever the case may be, where there's people involved, right? Let's just say that in any instance in which the McAlberts or anybody at that house was involved in what happened to him, or in the instance that it was a complete accident, that he just fell and no human was involved. Either way, how I see it is if he wasn't hit by a car, which I don't think he was, the only explanation for the taillight pieces getting there are that they were planted by law enforcement. And so I have to wonder if you're one of these jurors, right, if maybe you're thinking, okay, yeah, I don't think he was hit by a car, but then if you're left with, well, the only other explanation for the taillight pieces getting there is that law enforcement planted it. And I wonder if that was part of the struggle, because it's possible that those are two things that both sound really implausible, right? Like, it's implausible that he got hit by a car. It doesn't seem possible, given the injuries, given the testimony, given where he was found. But for some people, I could see them also thinking it also seems implausible that law enforcement would plant evidence. Now, I don't think it's really that far of a stretch when you look at the law enforcement who we're talking about here, right? And the jurors heard from it. But for some people, I could see how they're torn between those two things. Because again, no matter how you slice it, even if you're saying, I think the cover-up is a bit much, that's a bit of a stretch, and he definitely wasn't hit by a car, but the only explanation for those taillight pieces, no matter how you slice it, is either he was hit by a car or they were put there, right? And that's a tough spot to be in if you're a juror who's maybe thinking between those two things, right? Like, again, that's tough. Now, the issue, of course, is that the instructions that they were given is if there is evidence like that, right, where it could point to one side or the other, they have to go with whatever is more favorable to the defense. So if they were having that discussion, they should have ended up leaning over towards, okay, yeah, we're going to go with she didn't hit him, period. Whether it was intentional or accidental, or whether she even knew she did, like, again, going back to this statement, but that one step further, if she didn't hit him. And I just have to wonder if that's where that discussion ended up being, of like, some people just couldn't get there. They couldn't wrap their heads around the fact that somebody must have planted that evidence, that somebody must have put those taillight pieces there if he wasn't hit by a car. That's the only explanation, right? And the reverse is also true, because as we say, yeah, he definitely wasn't hit by a car, what we are doing automatically is confirming that the way those taillight pieces got there is because they were put there. That's also another thing, right? Because then it's like, well, the jury shouldn't have to be trying to explain how the taillight pieces got there. That's not their job. Their job is to figure out if Karen Reed killed John O'Keefe, right? But of course, the taillight pieces are just such a big part of it. It also kind of begs that same question if, the defense kind of making so much emphasis on, or putting so much emphasis on, the cover-up and the framing and stuff was a bit a bridge too far, as Judge Newman would say. But again, this is where it's funny, right? Because normally it's like, again, the conspiracy idea and the cover-up and all that is just a bit much for me. However, the very clear evidence is that he wasn't hit by a car, in my opinion, right? From the testimony from the medical examiner and from the experts, all the experts. I mean, honestly, even Trooper Ball proved to me that he didn't get hit by a car. And under that assumption, he was not hit by a car, there has to be a way that the taillight pieces got there, right? And there was enough activity with the law enforcement, right? With the lollipop and the inverted video camera. There was so much that was really suspicious, right? And the way that the taillight pieces showed up over time, you guys, I'm sure, are familiar. I'm not going to go through the whole list, but the only other explanation, and this wasn't offered because there's no proof of it, I'm just saying that hypothetically, the only other explanation would be that some other car accident happened on that road after John O'Keefe was already found. Somebody's taillight got knocked out, some other person, right? And that's how the taillight pieces got there. That's the only other explanation apart from them being put there by law enforcement. So anyway, that's my thoughts on these latest documents. We've been taking a break from the Karen Reed coverage, and so we still have a little ways to go to finish the recaps, but I think everyone's been enjoying having a little bit of break. It was very much requested in the wake of this mistrial and all the shenanigans. However, I know that everyone still is interested, and I'm still interested in covering the hearing, as it will happen on Friday. But in the meantime, I've been doing coverage of the Wisconsin versus Ezra McCandless trial, And I do have a playlist for that as well, and I will link that in the video's description, and it should also show up at the end of this video for you guys if you're interested. But it is a really interesting trial that has never been covered gavel to gavel on YouTube with any type of commentary or analysis. And so this is a YouTube first. So we are covering it gavel to gavel. Currently we are on day 3. If you are interested, while we are kind of in a bit of a lull trial-wise right now, and also kind of, you know, taking a little bit of a break from Karen Read, if you're interested, this is a really great trial that has really stellar lawyering on all sides. The judge is also phenomenal. There's really great argument. And another thing that's really unique to this trial is that whenever they're putting things on the record, like during like housekeeping, you know, during the day or at the beginning of the day or at the end of the day, this judge does something really fascinating, which is they talk about the sidebars. And I think it's because he's just he's taking notes and he's kind of putting it on the record for himself because, of course, transcripts are not available until much, you know, later after the trial. And so, you know, just like with everything else that we've seen, you know, they have their sidebars and you don't get to hear that. But once the jury's gone, they talk about the sidebars and what they are, and they argue, and they talk about what they said and what was decided, and then they have further argument about it. So you actually do get to learn. Well, you don't get to hear the sidebars, right, obviously, or read transcripts of the sidebars like we ended up getting in Debbie Heard. This is the next best thing, which you get to hear them talk about what they said at the sidebar. So you do learn the content of the sidebars, and you do hear them bring up things like there was a motion in limine about this or that. So that is another thing that's really unique to this trial. And anyway, so if you are interested, definitely check that out. And make sure that you are subscribed and have notifications turned on so that you don't miss a live stream. And other than that, thank you guys so much for watching. Thanks for being a squirrel, and I will see you guys on the next video.